Right. Let's unpack this. Today, we're diving deep into a monumental legal battle that's reshaping the entire tech world.
Yeah.
The groundbreaking antitrust ruling against Google.
hmm
And crucially, the court's recent decisions regarding the remedies, this isn't just legal jargon, right? It's
Yeah.
about how the internet works, how you find information, and, well, who benefits.
Exactly.
Our mission today is to truly deep dive into this remedies phase. The court found Google a monopolist. We know that. Now, what did it actually decide to do about it?
Yeah, what's the follow through?
Precisely. What does this mean for how major tech players like Google, Apple, Microsoft will operate? And, what about the exciting, rapidly emerging AI powerhouses, OpenAI, Perplexity?
Right.
Ultimately, what does all of this mean for you, the user, in your daily digital life?
What was fascinating here is that the core finding was absolutely clear. Google violated Section 2 of the Sherman Act. That's the bedrock, the foundational antitrust law designed to, prohibit monopolization, preserve competition. And for over a decade, Google leveraged these sophisticated distribution agreements. They paid billions to lock up default search positions across devices, browsers.
Mm-hmm.
This effectively choked off competition. It starved rivals of the crucial data and scale they needed to genuinely compete, and of course, enabled Google's monopoly profits.
Yeah.
So the court's task now is, well, it's monumental, almost philosophical, you could say, to pry open to competition a market that has been closed.
So the initial verdict, which, yeah, we've discussed before, was unambiguous. Google is a monopolist. But then came what I think many would agree was the truly contentious part, maybe even dramatic.
The remedial phase.
Exactly. This is where the plaintiffs, the U.S. government, and various states and Google itself presented their, well, wildly different visions for the future.
Very different.
Google, predictably, argued for minimal changes, really surgical stuff, while the plaintiffs pushed for a comprehensive and unitary framework to, fundamentally reset the entire market.
And this phase truly highlights the inherent tension, doesn't it? Between strict legal interpretation and the incredibly fast-moving, complex landscape of the tech market.
Absolutely.
The court faced a really complex balancing act. They needed to deny Google the fruits of its violation, basically, stop them benefiting from the illegal conduct, but also avoid unintended harms to the broader tech ecosystem.
A tricky line to walk.
A very tricky line. And it's worth remembering, the court explicitly stated it has no expertise in the business of GSEs, that's general search engines,
Right.
or the buying and selling of search text ads or the engineering of GenAI technologies. They actually admitted needing a healthy dose of humility when trying to look into this crystal ball of future tech and decide on remedies. It's a huge responsibility.
That humility certainly seems to have guided some of their decisions. Let's start with the foundational changes the court did decide to impose regarding Google's existing agreements. Google itself had proposed an injunction against its exclusive agreements. Things like conditioning Play Store licensing on preloading Google search, or tying revenue share for one Google app to another.
Standard tying arrangements, yeah.
The court accepted these prohibitions, but, and this is key, with some very critical modifications.
Right, and this is where it gets particularly nuanced, I think.
Yeah.
When we look at the court's modifications, the court found Google's own proposals, while they were a start, but simply insufficient.
Not enough. Why?
Because the market is characterized by these powerful network effects.
Mm-hmm.
The more users, the better the engine gets,
Mm-hmm.
and a strong default bias. Users just rarely change pre-selected options. These are forces Google masterfully exploited.
Yeah.
So simply stopping exclusive deals wouldn't by itself restore genuine competition. So the court imposed a crucial change, a one-year term option for OEM and wireless carrier agreements. 1 year. This mirrors what already exists for browser agreements, allowing partners like Samsung, Motorola, AT&T, Verizon to switch their default search engines annually.
Okay, that forces a yearly decision point.
Exactly. And critically, this now extends to GenAI products. That means Google can't secure exclusivity for its AI services on browsers or devices either.
Ah, so it covers the new stuff too.
It covers the new stuff. This transforms Google's relationship with its partners. It's not perpetual lock-in anymore. It's an ongoing year-by-year competitive negotiation, potentially opening the door for new players, like Perplexity, like OpenAI, to secure crucial distribution.
That one-year term option sounds like a significant shift, even if it's not, flashy. Now, the plaintiffs really swung for the fences, didn't they? Pushing for structural relief.
Oh, yeah.
That's essentially forcing Google to sell off key parts of its business. They demanded Google divest Chrome, its browser, and even a contingent divestiture of Android if the initial remedies didn't work. That sounds like a pretty dramatic move.
Huge moves.
What was the court's thinking there, and why did they ultimately decide against such a, radical breakup?
Well, the court rejected both structural remedies, and this move is pretty consistent with that earlier expressed humility regarding, deep intervention into a company's core assets.
Okay.
While Chrome's significant role in Google's dominance was acknowledged, it accounts for roughly 20% of all U.S. searches, with Google obviously self-preferencing its own search there.
Right.
The court emphasized these were lawfully acquired assets. Divestiture, the court noted, is a remedy imposed only with great caution.
So a very high bar.
A very high bar. Breaking up Chrome, a product Google built from the ground up, billions invested, was deemed a poor fit, incredibly messy and highly risky.
Let's see how.
Well, it could lead to substantial product degradation and a loss of consumer welfare for the very users Antitrust aims to protect. The court just wasn't willing to dismantle a unitary company without stronger justification directly tied to the specific unlawful conduct. And the same logic, focusing on lawful acquisition and potential consumer harm, applied to rejecting the Android divestiture. It's a clear signal. The court isn't interested in wholesale corporate restructuring unless it's absolutely necessary and directly linked to the proven illegal acts.
So it sounds like the court is saying, we'll intervene where the conduct was unlawful, but we're hesitant to dismantle a company's fundamental architecture, even if those parts contribute to dominance. That seems like a consistent philosophy.
I think that's a fair summary, yeah.
Okay, let's move on to behavioral remedies, the rules for how Google operates. This was a particularly mixed bag of outcomes. One of the most talked about proposals was a complete ban on Google making search-related payments to distributors. No more billions for default placement.
The big money.
Exactly. Given how much Google pays companies like Apple an estimated $20 billion worldwide in 2022 alone, tens of billions domestically, this would be massive. So what does this all mean for those companies? Did the court go for it?
Not yet. And this is perhaps one of those critical decisions in the whole remedy phase. The court declined a payment ban at this time.
At this time. So deferred.
Deferred. And this raises an important question for the entire ecosystem. Why wait? Well, the court saw a substantial risk of harm to OEMs, carriers, and browser developers. We're talking major players: Apple, Samsung, Motorola, Mozilla, AT&T, Verizon.
Right, that's a lot of the infrastructure.
It is. Without Google's payments, these partners would face a Hobson's choice, essentially an illusory choice, where the only real option benefits the other party.
Meaning
They'd either stick with Google for free, which primarily boosts Google's own profits, or switch to a lesser quality GSE, a general search engine, for significantly lower revenue.
ouch.
Yeah. This could cripple smaller players like Mozilla, which relies heavily on these payments, and it could significantly impact tech giants like Apple, who use this multi-billion-dollar revenue stream to fund other R&D product innovation. So the court made a clear decision here. Prioritize the financial stability of the existing ecosystem over an immediate, radical financial shock that might actually reduce competition in the short term.
But what about the long term? Did they address that?
They did. The court noted the explosive rise of generative AI products. Hundreds of billions of dollars now flowing into companies like OpenAI, Anthropic, Meta, Perplexity.
Yeah, the whole AI boom.
Exactly. This new competition offers, in the court's words, hope that Google will not simply outbid competitors for distribution if superior products emerge. This emergent AI market, perceived as highly competitive, weighed against immediately disadvantaging Google.
So it's a strategic deferral.
I'd say so. The court is effectively betting on the nascent AI market to disrupt Google's distribution leverage, rather than imposing an immediate financial shock.
Yeah.
But importantly, it also explicitly states the court is open to revisiting a payment ban if competition doesn't improve over time. It's a high-stakes gamble on the future of AI.
That's a huge decision with major implications across the industry, especially, like you said, for players like Apple who benefit immensely from those payments. Okay, now let's talk about Google's secret sauce. It's data.
The data.
Plaintiffs argued that access to Google's vast data is truly at the heart of its massive scale advantage. What kind of data was Google actually ordered to share? And just as importantly, what was kept private?
Right. The court did mandate data sharing. They recognized it as critical to help rivals overcome Google's massive scale advantage, calling it well within the range of ordinary Sherman Act remedies.
Okay, so what kind of data?
First, for search index data, Google must share a one-time snapshot of its core web index. Think of it as the foundational map of the internet Google has built.
Like the phone book for the web?
Kind of, yeah.
Yeah.
Unique document identifiers, docket deeds, web addresses, URL maps when they were last indexed, even internal quality scores like spam flags and device type flags. This is specifically to help new players like OpenAI, DuckDuckGo, Perplexity jumpstart building indexes at scale without having to recrawl the entire web from scratch.
Right.
Which is, a monumental, costly task.
Makes sense. But what didn't they have to share there?
Crucially, the court rejected sharing Google's proprietary ranking signals like popularity and quality scores and periodic disclosures. This was a move to prevent free riding, basically, and protect Google's innovation incentives. They want rivals to build their own smarts on top.
Got it. That's a huge amount of fundamental information being unlocked, though. But what about the more dynamic stuff, the user-specific data that really refines a search engine's quality?
Exactly. Moving to user-side data, Google is also ordered to share what are called glue and rank embed data, at least twice.
Glue and rank embed.
Yeah. These are the granular records of how users actually interact with search results. We're talking query click patterns, how long users hover over a link, even follow-up searches.
The behavioral stuff.
This is truly Google's bread and butter of scale advantage. It's critical for understanding nuanced user intent, improving search relevance, especially for those obscure long-tail queries.
Right.
Companies like Yahoo and DuckDuckGo testified this would accelerate by years their ability to create competitive indexes. Anonymization will be required, obviously, to protect user privacy. That's a crucial point.
So really valuable interaction data. What wasn't shared then? Anything else kept private?
Yes. The court rejected demands for Google's knowledge graph data, found it too attenuated from core user data, too highly engineered.
Okay.
It also rejected GenAI model training data, not enough evidence linking Google's search scale advantage directly to GenAI quality. And ads data was rejected too, citing a poor fit with the liability findings and significant privacy concerns for advertisers.
So it's a targeted release of highly impactful data, but definitely not opening the kimono completely on all of Google's intellectual property.
Precisely, a calculated approach.
Okay, so some key data points are being opened up, but not everything. Next up, syndication remedies. This was about giving rivals a leg up while they build their own tech. Plaintiffs proposed syndication, basically letting competitors license Google's search results and ads.
Right, like a temporary boost.
How did the court rule on this one?
The court agreed that syndication is a reasonable method to provide a crucial bridge for qualified competitors. It lets them offer good results immediately without building everything from scratch.
Makes sense.
However, it was significantly narrowed compared to what the plaintiffs wanted. For search syndication, Google must syndicate high-quality web results, but only for a 5-year term, not the 10 years initially sought.
5 years. Why 5?
Probably balancing the need for a bridge with not letting competitors rely on it forever. This is meant to help competitors like OpenAI and Perplexity offer credible results, especially for those tricky long-tail and local queries.
Okay.
But here's a critical distinction. The court rejected marginal cost pricing. They required a market rate instead.
So Google still gets paid properly?
Exactly. And the aim is to incentivize competitors to invest in their own technology, not become permanently dependent on Google. There's also a tapering provision, gradually reducing the percentage of queries they can syndicate annually, starting at 40% cap in year 1 for certain query types.
Okay, a gradual weaning off. What about ads?
Similarly, search text ads syndication must be provided for 5 years at market terms. This lets new entrants monetize their offerings right away, generate revenue they can reinvest to improve their own search quality, maybe even build their own ad platforms eventually.
Makes sense. Same logic.
Right. Again, the court rejected granular ad data sharing and marginal cost pricing to protect Google's IP and avoid stifling competition in the ad syndication market itself. And one more crucial point. The court explicitly rejected proposals that would let rivals replicate how Google delivers its SRPs, or scrape syndicated results.
No cloning.
No cloning. The goal is to level the playing field, not just copy Google's homework.
That distinction between leveling the field and cloning Google's IP seems really important. Okay, Beyond the internal workings, one of the most widely discussed proposals, and something many of you listening might have hoped for, was the choice screen,
Ah, yes, the choice screen.
where users would explicitly pick their default search engine on new devices or browsers. This seems like such an intuitive solution for promoting competition, right? Did the court see it that way? Will you finally get a clear choice?
Well, unfortunately for those hoping for that clear choice, the court declined to impose choice screen remedies.
Really? Why not? It seems so straightforward.
It does seem straightforward, but the reasons for rejection were multifaceted. And they reflect that earlier stated humility. Courts are just inherently wary of redesigning products. They stated such product design mandates are not a proper task for the judiciary.
Okay, not their job.
Plus, evidence from Europe, where Android choice screens already exist, showed little shift in market share away from Google, only like 0.5% to 1.5% decline.
Wow, that's tiny.
Tiny. It suggests simply offering a choice isn't enough if the alternatives aren't perceived as equally good. Apple's Eddie Q even testified that a choice screen is not going to matter until one of the choices is actually really valuable that provides new capabilities.
So quality still trumps choice architecture.
Essentially, yes.
Yeah.
The court is saying that without a truly competitive alternative in terms of quality and innovation, a choice screen offers no genuine choice that would meaningfully disrupt Google's dominance. It kind of puts the burden back on the competitors, even if the playing field isn't fully level yet.
That's certainly a blow to those hoping for a simpler way to pick their search engine. Suggests the court is looking for deeper market forces to drive competition. Okay, shifting gears slightly beyond the core search experience, the court also looked at Google's relationship with advertisers and publishers. What did it decide about ad transparency for the companies spending all that money with Google?
There was one notable win for advertisers here. It aims to provide more accountability. Google is now required to report monthly changes to its search text ads auctions.
Monthly reports. What's the goal there?
The aim is to prevent Google from making pricing changes without meaningful competitive restraint, a behavior observed in the past that could harm advertisers. This increased transparency should give advertisers more meaningful insight, letting them make more educated decisions about ad spend, maybe pressure Google for fairer pricing.
Okay, so more visibility into auction changes.
Right. However, the court rejected demands for more granular search query reports, SQRs, and reinstating true, exact, match keyword options. They found those either too vague, outdated, or not directly linked to the specific monopolistic conduct Google was found liable for.
So a targeted win, not a wholesale change.
Exactly. And publisher-related remedies like prohibiting exclusive content deals or requiring opt-outs for GenAI training were also rejected. Lack of factual basis outside the scope of the original findings.
Got it. So with all these changes and mandates, how will the court ensure Google actually complies? What kind of oversight, what kind of enforcement did they put in place to police such a complex technical decree?
Well, first, the court rejected broad anti-circumvention and anti-retaliation provisions that the plaintiffs wanted.
Why reject those? They sound important.
They sound important, but the court found them too vague, not compliant with legal requirements for injunctions, which need to provide explicit notice of precisely what conduct is outlawed. The court really wants clear, actionable rules, not broad prohibitions.
Okay, clarity is key. So what did they put in place?
This is critical for navigating such a complex case. They did establish a technical committee. This committee will assist the plaintiffs and the court.
What will it do?
It's not a neutral arbiter, but rather an expert body to advise. It'll weigh in on the highly technical aspects of the data sharing and syndication remedies, ensure proper anonymization of user data, help set parameters for reporting those ad auction changes we talked about.
So like technical advisors to the court and plaintiffs.
Exactly. This expert body is crucial because, let's face it, the judiciary lacks direct technical expertise. The committee ensures continuous informed monitoring of technical compliance and helps prevent Google from finding loopholes through technicalities. It's an acknowledgement that effective enforcement in tech requires specialized knowledge.
That makes perfect sense. You need a technical ear on the ground. Another interesting point here. Plaintiffs tried to get the court to prohibit Google from self-preferencing its own products.
Right.
Things like AI Core, Circle to Search, Google Lens, where Google's own services are prominently displayed. What was the court's view on stopping that?
The court rejected these prohibitions as well.
Really? Why? That seems like a core issue.
Well, the court found these actions were not of the same type or class as the unlawful acts Google was found to have committed. Remember, that was primarily about securing default positions through payments and exclusive deals.
Okay, different category of action.
Different category. Furthermore, the court noted that leveraging proprietary products to distribute AI tech is, frankly, commonplace in the GenAI space. Meta does it with Instagram, WhatsApp, xAI with X, Microsoft with Edge Bing.
True.
Circle to Search and Google Lens, for example, were seen more as new channels of search distribution channels that the court's existing remedies, like the one-year contracts, aim to open to competition. They weren't seen as self-preferencing within the scope of the original monopoly finding.
So the court seems to be drawing a line between creating new distribution channels and unfairly foreclosing existing ones through those illegal deals.
That seems to be the distinction they're making, yeah.
Okay. This whole deep dive started way back in 2020 with the initial complaint, and we're now in September 2025 as these remedies begin to roll out. How long will these highly anticipated changes actually be in effect? Is this permanent?
Not permanent. The court imposed a 6-year term for the final judgment. 6 years. That includes 1 year for establishing the technical committee and implementing all the new processes.
Yeah.
The remedies themselves become effective 60 days after entry.
How does that compare to what the parties wanted?
Google wanted a shorter 3-year term, arguing, the market changes too quickly. Plaintiffs pushed for 10 years, wanting more time for effects to take hold.
So 6 years is a compromise.
It seems like a balance. It acknowledges the rapid pace of technological change,
Yeah.
especially with GenAI exploding, but also provides sufficient time, hopefully, for the remedies to have positive market impacts and allow competitors to truly scale.
Any precedent for that length?
Yeah, it's actually consistent with historical precedents, like the big Microsoft antitrust case back in the day. That also used a 5-year term due to rapid industry changes.
Right.
And as Apple's Eddie Q summarized it, for the first time, I think there's an opportunity to challenge Google because there's new technology. This 6-year term aims to facilitate that opportunity, but it also gives the court a window to reassess as the AI landscape inevitably evolves.
So there you have it, a nuanced, carefully sculpted set of remedies. It sounds like while some of the really big bang proposals, like breaking up Chrome or that immediate ban on Google's multi-billion-dollar payments, were rejected,
Right, the headline grabbers didn't happen.
the court has mandated significant changes to data sharing and syndication. The fundamental aim seems to be leveling the playing field for competitors.
That's the goal, yeah.
It definitely creates a new reality for Google, which now has to share some of its most fundamental data and services. And for other tech giants like Apple, who now have a clearer path, though still a challenging one, to maybe fostering competition in the search space on their platforms.
And if we connect this to the bigger picture, the court's approach really reflects a cautious but firm hand, I think.
How so?
Well, it's an acknowledgement of both Google's past anti-competitive behavior and the dynamic, unpredictable nature of the tech industry, especially with this explosive rise of GenAI. The idea here seems to be creating conditions where markets are often more effective than the heavy hand of judicial power, as the court put it, but with a clear path to judicial intervention if needed. It reminds us that constant oversight and adaptation are still key.
So less about punishing Google and more about trying to create fertile ground for innovation and choice,
Yeah.
banking on new tech to disrupt old monopolies.
I think that captures the spirit of it, yes.
Yeah.
It's trying to enable competition rather than dictate the outcome directly.
Okay. And that leaves us with a provocative thought for you listening. In this newly shaped search landscape, with AI innovations changing everything, what unexpected challengers might truly emerge? And how will you discover them? Will these remedies actually be enough for a genuinely new default search experience to appear on your phone or browser? Or will the power of defaults and those network effects we talked about remain just too strong?
It's the multi-billion-dollar question, isn't it?
It really is. We'll certainly be keeping an eye on it.